Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elevate.net, ELAWVATE.net, or go online to elevate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elevate.net or fill out a case workshop request at elevate.net. And Rahul and I will look forward to chatting with you soon. This episode of the Elevate podcast is brought to you by FileVine. FileVine has a software program called Lead Docket, which is the gold standard for managing your new case intakes and leads, your Glengarry leads, your Glenn Ross leads, and all of your other leads. So check them out at FileVine and manage your leads. We're also brought to you by Steno. Rahul, you guys work with Steno?
Steno is the best in court reporting services, not just in court reporting services, but even some of their technology tools. We're talking about AI a little bit on this podcast, and their transcript genius, where they can summarize and take interrogatories based on deposition transcripts, is so useful. If you haven't tried it, definitely try it.
We're brought to you by Hype Legal. Hype Legal does digital marketing, web development for trial firms. It's owned by our good friends Micah and Tyler. They recently redeveloped our firm's website, so you can check our website out. If you like it, give them a call, and they can help you out too. And finally, we're brought to you by Expert Institute. Rahul, you guys work with them, right?
We both use Expert Institute because you always need to be cutting edge in the experts that we use in our cases. Going to the repeat experts every single time is going to make you a lesser lawyer, and you always want to keep up, and the best way to do that is with Expert Institute.
Welcome to the Elevate podcast. I'm Ben Gideon. Rahul is off today picking a jury in one of the first social media trials in Los Angeles, so we'll be looking forward to hearing more about how that goes. It's my great pleasure to welcome Shanin Specter to the podcast today. Shanin is somebody who we all know in the trial lawyer community, a founding partner of Shanin Specter, a powerhouse trial firm out of Philadelphia. Shanin has tried every type of plaintiff's case you can imagine: products liability, medical malpractice, personal injury, and others. He has over 300 verdicts and settlements of greater than $1 million, more than 10 verdicts over $10 million, and several over $100 million. In addition to that, he teaches and is busy educating the next generation of trial lawyers. He has also built one of the top plaintiffs firms in America. So I'd be very interested. And I understand you're also an avid squash player in your free time. So, which I guess explains your apparent fitness level. You seem very fit. Are you still playing squash?
Yes, I played yesterday and I'm playing later today.
I have to confess, that's one sport I've never tried. I grew up playing a little bit of racquetball, and I've played some paddle tennis and so forth. But how to squash? What draws you to squash?
Really, fitness, and it's a way to get and stay fit. But part of that also for me is that I like the competition of playing against someone else, and I like banging a ball into the wall. And it's more interesting, I think, than being a gym rat. I do some of the gym rat stuff too, because the reality is that you can't stay on the squash court unless you are working on your fitness. It requires too much flexibility. to just simply rely upon playing squash just to stay playing squash. You have to be in the gym and have a significant routine on core and strength and flexibility and the like. So I work with a trainer 2 days a week to help me on those things as well.
It strikes me that you're inherently a fairly competitive individual.
I think that that's true, but I hope that it's tempered by perspective and maturity, and that it not consume me. And I don't think I've ever been consumed by competition. I think, Ben, some of our colleagues may find themselves occasionally consumed by competition, and it's not healthy.
So that's a good segue to the my first topic for you, Shane. And obviously, you grew up as the son of a very prominent person. Your dad, Arlen Specter, was a longtime senator from Pennsylvania back in the day when there were such things as moderate Republicans, very well respected across the aisle. You chose a different path, building a very successful business that I'm sure employs lots of people and has generated, great economic wealth for them and their families and your community, trying many cases, landmark cases, having big impacts on individuals through those cases, but also societal impacts as it's caused social change. What career do you think in the modern day can have a bigger impact? Because I wonder about politics today. I have, some limited exposure to that. Where can you have a bigger impact today? Politics or the private sector? And how do you compare those kinds of the impacts you and your dad have had in the world?
Wow, that is such a great question and so difficult to answer. And I'm tempted to throw up my hands and say that public service is hopeless and we should turn inward, including trying to effectuate change through the private practice of law by insisting, for example, on remediation by a defendant as a condition of settlement, which you referenced a moment ago, and which our office does in the appropriate cases. And we've been very successful in getting companies and governments and others to change their behavior, which has made the community and the country safer. So that's a way to make a great contribution to the public good. And that's in the private sector, isn't it? Obviously. And if you're able to be successful financially in the practice of law or otherwise, it gives you the opportunity to engage in philanthropy. And that's something that my law partner, Tom Klein, and I have worked on. And we feel very good about what we've been able to do, again, to help our community through philanthropy. So I am tempted to say that the private sector, private law practice, and the like bears more potential for making contributions. But I do think that this very frustrating time that we're in now, and that, of course, is a euphemism, but this very frustrating time that we're in now will pass. And this nation will be rid of Trumpism when Trump leaves the scene. There's no political philosophy behind the president. There's no overarching movement behind the president. It's all a matter of cult of personality. That's all it amounts to. And so when he leaves, and of course he will leave, we're all human, we all leave eventually. I think that the vestiges of what he is leaving behind will leave with him. And I think that we can expunge the worst of what his administration is doing, I hope quickly. And that's not to say, Ben, that everything that they're doing is wrong. I agree with some of the things that they're doing. But overall, it's been very frustrating for me as uh, someone involved in politics and public life for decades to see what's happening in our country. May I add one aspect, and that is that I think all of us who practice law who have access to the courts, who have resources, who have people who will help us, should be looking for opportunities to litigate with the Trump administration or about the Trump administration where it's suitable for our practice and for our interests and for our clients. And our office has done that. And we look for more opportunities. We started a democracy practice last year. We actually have a drop down on our website called Democracy Practice. And we have a whole bunch of cases, some of which have nothing to do with President Trump, but simply are about advancing democratic values, such as a lawsuit we have in Pennsylvania now to try to force the Commonwealth to open primary election voting to unaffiliated so-called independent voters. We're one of only 9 states that does not permit independents to vote in party primaries, which effectively disenfranchises them. And so we have brought a constitutional challenge under our state constitution in that regard. And we're trying to win that. By the way, if we don't win it in the courts, we're trying to win it first or later in the legislature. And even beyond that, the parties themselves can decide to open themselves up. And I've been talking to the state party chairs, both Republican and Democrat, both of whom I know well, and about opening up, just resolving to open up their party primaries to independent voters. So there are a lot of things that we can do. And I am optimistic. And I think that we're going to get beyond this. Sorry for the long answer.
No, it's such an important topic right now. We just had ICE has moved aggressively into Maine, and so there's a lot of issues that are coming to the surface, and we've offered our services to people who need help or just want to reach out to lawyers or law firm, and we're going to try to find a way to be part of that as well. I think it is really important. So another topic kind of relating, I know one of the things on your CV is that you've gone to law schools and you give a speech entitled "How to Find a Job You Really Love" or something like that. What are you telling law students about that?
Thanks for bringing that up. Yes, the speech is called "How to Get a Job You'll Really Like," and there are a bunch of versions of it on YouTube. You could just put in my name and that title, and it comes up. I have given it to many law schools, giving it again in a couple of weeks at UC Law San Francisco, which used to be called Hastings. What I'm doing there is I'm trying to provide students with other options. You don't have to, go to the on-campus interviewing. You don't have to get swallowed up by BigLaw, which I think many of us know. BigLaw has become even more aggressive in capturing law students. They're now hiring first semester, first year law students for their projected 2L summer. So you come into law school in late August, and one of the first things that happens is you start getting contacted by large law firms saying, come join us for your 2L summer. They're not even asking you to come for their 1L summer. They want you to come for the 2L summer. And then they'll pay you a bonus for working there, for agreeing to work there for the 2L summer, such that you don't have to work in your 1L summer. In fact, they encourage you not to work in your 1L summer because they don't want to have any competition to capture you permanently as an associate in the firm. I mean, it is so venal and craven what they are doing, and nobody is stopping them, which is also a disgrace. And I'm saying to law students, you don't have to put up with that bullshit. Get a job on your own. Figure out what areas of law you like. Figure out where you want to live. Figure out who are the best legal employers in that area of law, in that geographical area of the country. That, by the way, is very easy to do. If you want to do trust and estates work in Spokane, Washington, right, all you got to do is go into your iPhone and type in trust and estates lawyer, Spokane, Washington. A bunch of names are going to come up. It's easy to research them online. And law students are very good at that, aren't they? And so then you should contact those law firms or those legal employers directly. Send them letters and emails. I say letters because we lawyers, Ben, we don't get any letters anymore, do we? My God, if we get a letter, it's like a cause for celebration in the office. Oh my God, I got a letter. I read every letter I get carefully because I get so few. So I urge law students to send letters to potential legal employers. I say send it by both U.S. mail and by email. And of course, part of our problem as lawyers as well is we have all of these barriers to getting emails through to us because our IT people tell us that our systems can be corrupted. So counterintuitively, it may be easier to reach Ben Gideon or Shanin Specter by sending us a letter than it is by sending us an email. The emails may get blocked, the letter will get through and will get read. So I urge students to use both modalities and then reach out for the firms and ask for interviews, either informational interviews or job interviews. And I tell them, this will work. You will get a job this way. And for the half of law students who are in the bottom half of the class, if they reach out to law firms that aren't on the beaten path for law school recruiting, not the big law firms who do demand transcripts, but if you're just again giving the apocryphal example of the trust and estates firm in Spokane, if you're running the trust and estates firms in Spokane, they're not likely to ask you for your transcript. They want to see your resume and they're very impressed to see your letter and they'll want to read its content and they're going to talk to you, but they may not demand your transcript. So that's another way through it for that half of law students who are in the bottom half of their class. And so this formula that I have articulated has worked for hundreds of law students, and it's a much more sensible path to finding a job than to think that on-campus interviewing is going to be a panacea for your job interests.
Did some of this come out of Clyde Inspector having difficulty finding highly qualified candidates?
No, it came out of my own experience as a law student. I was counseled not to get a job through the career office and instead to get a job on my own and to write to good lawyers and to ask for summer employment. And I thought that was a deceptively elegant and sensible way to approach getting a job. I mean, think about it this way, Ben. Every law school has a career office. None of them need career offices. They could all be disposed of. We don't need a career office in a law school. In fact, if you think about how Americans get jobs, less than 1% of Americans get jobs through career offices supplied to them by money they're paying to, an educational institution or otherwise. People get jobs on their own. You get a job by scouring websites, by going on LinkedIn, by looking at classified ads, by talking to your friends and your family. There's a million ways of getting a job, but a career office is not the way people get jobs for the vast, vast majority of Americans. We don't need career offices in law schools. I know that's sacrilege, at least for the career office people, it's sacrilege, but we don't need them. And it's really not benefiting the law students.
No, I agree with that. I mean, I think I communicated with you, but I was invited to go speak to the National Plaintiffs Law Association at Yale Law School about, I don't know, 2 months ago. And I went there and there were about 50 students in the room and very interested and engaged. And, in my experience when I was there, the career office had set up the on-campus interview process at a local hotel. You were going room to room with all the white shoe big law firms, and they were, aggressively recruiting and signing people up. And it does seem somewhat, I hadn't thought of it this way, but it does seem somewhat inappropriate because the law school is really serving as a feeder system for that one niche of practice, which one could say is not necessarily the highest and best use of new lawyers in America. I mean, Cravath probably has plenty of competent lawyers and doesn't need the next one. And I was asking about Clyde Specter because we currently have an opening for a trial lawyer at our firm, and we're having we're in a small state, a little bit out of the way, but it's a great opportunity. I think it would be a great job for the right person, but just finding that right person with the right mix of qualities for that in a small, out of the way state is very difficult. So if I got a letter from somebody interested, I would certainly read it and be very excited to receive it. So I think that's great
Yeah.
advice.
And can I ask you about the opening that you have Are you limiting yourself to lawyers that have a license to practice law in Maine?
No, we'll take a lawyer. I mean, we want somebody on the ground here, so they'd have to move to Maine,
Sure.
but we'd be happy to have somebody who wanted to move here and take, pass eventually matriculate into the Maine bar. We did initially try to mine the local market for everybody we knew that might be a good candidate, but it's just few and the slim pickings in our home state for people. But your example about Spokane, Washington is so correct because every small to mid-sized market has, I think, a deficit of quality lawyers that are available for hire, and every firm in those markets needs people. That's my experience, especially in a state like Maine. I mean, you can go out of any of the somewhat larger cities to any of the small towns, and they're all underserved by lawyers. And there are great opportunities in all of those places, but nobody really knows about them. With a little diligence, you could be making, mid six figures in a small community, be a big wig in that community, and have a really nice quality of life rather than slaving away 80 hours at a big firm in Manhattan, which is where I started my practice. So just in full
Yeah.
disclosure, but
But may I mention to you and to the folks who are listening to our podcast that the National Plaintiffs Law Association has a job board. At this point, that organization is becoming mature. Not only are there a lot of law students who check their site and the like, but now they have graduates who are out in the practice of law. And maybe those graduates didn't end up going to a firm with which they're happy. It could have been a defense firm or public interest or a prosecutor's office or what have you. And that's a good place to be for we law firms to be looking for recruits. And of course, anybody that is on that NPLA site has some idea about what we do and thinks it's good. So it's a very useful place to go to get resources.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
so I want to switch gears a little bit and talk to you about trial practice. I mean, you recently had a great verdict in a trial. I think it was in Chicago, right? In a
Yes.
Boeing case.
Yes.
So you're still actively trying cases. You probably don't need to be at this point in your career because you have other people in your firm who are very highly competent at trying cases. But are you still enjoying doing trials?
Yes. It's interesting you say you don't need to be trying cases. Maybe I don't need to be trying cases economically, or maybe I need to be trying cases from the standpoint of my role in the law firm. But I think that for myself, I think that it is enjoyable, though stressful. It's healthy stress. I think it's a healthy amount of stress to be trying a case, and it's interesting and productive. So yes, I'm still trying cases, and I'm still enjoying trying cases. The case I tried in Chicago was against Boeing in relation to the Ethiopian Airways crash that occurred in March of 2019. That was the second of the two MAX 8 crashes. It's the one that caused the FAA to ground the MAX 8 fleet of aircraft across the United States. And I'm sure everybody listening remembers that terrible tragedy. Here's what folks don't know. there were 157 people that died on that plane. There were 157 lawsuits. By November of last year, 2025, so we're talking about 6.5 years after the accident, 146 of the 157 cases had been resolved. No case had gone to trial. No case had gone to trial. So we were down to 11
Why is that?
cases because Boeing admitted liability, which on their part was smart, and they were paying significant sums to settle the cases. And lawyers and clients working together decided to not have any of the cases go to trial. And no case was going to trial. And in my situation for that particular client, he was interested not just in an economic recovery, but interested as well in the public information value to not only the United States, but to the world of having one of these cases be tried. And the family who I represented was Indian. The decedent was a young woman working for the United Nations. Her husband was also a United Nations staffer. And there was a UN conference in Kenya that the decedent and others on that plane were going to. There were several conferences in Kenya that outstanding young citizens of the world were going to. That terrible, terrible plane crash took the lives of so many talented and aspiring young people. And this young woman was one of them. And the family recognized the limitations of financial compensation, and they recognized the benefits of having a public airing their loss. So I felt particularly good about trying that case. More than the verdict, more than the amount of the verdict, I felt that it was important that that we bring to the public's attention one of these stories, and that there be a trial, and that not every single one of these cases just simply gets settled.
And how much were you able to get into any of the um, liability or defect issues in the trial, or was it solely a damages trial?
We were not able to get into the defect issues at all, which of course is regrettable. But when Boeing elected to admit liability, that takes the issues about the problems with the airplane off the table. But of course, we were able to talk about what occurred during the flight, during the 6 minutes the plane was in the air while it was gyrating up and down because of the problems with the plane. We couldn't explain what the reasons were. The plane was gyrating up and down, but it was obviously a defect issue. And the fact that that the judge did tell the jury that Boeing admitted responsibility for the death of our decedent and the others on the airplane tells the jury squarely that there was a problem with the airplane. But we couldn't get into the exactly with what the problems were. And of course, I think that does affect the jury's consideration of the case in some ways. But even just, Ben, limiting the discussion to what one family lost, to the grief of the husband, to the loss of the marriage, to the loss of the earning capacity of the decedent, which permits you, of course, to get into what she was doing and the importance of her work and her career path and the like. And in her case, she was an environmentalist working for the United Nations. And those are important things to say. And of course, the jury was also asked to award a fair sum for the pre-impact fright of the decedent. And, that plane crashed essentially nose first into the ground. And there was some period of time, a minute, 2 minutes, 3 minutes, it's hard to know for sure, that everybody on that plane knew that they were about to die. So that's also an important thing to discuss. I mean, it's a horrible thing to discuss, of course, but it's an important thing to discuss publicly, at least in one case, and have a jury decide what's the appropriate financial valuation to place on that experience. And I think that all of us, when we're looking at our cases, some number of the cases that you're working on have a greater public impact potentially than others. And you know what they are, right? That maybe the intersectional collision, between grandma and teenager doesn't have any societal ramification beyond the two families involved. But an airplane crash caused by a defect in a Boeing airplane, that has a potential impact literally on every human being in the world, because all of us are dependent on Boeing. Every single one of us. You can't fly in this world without getting on a Boeing plane. Well, I suppose you could if you were extraordinarily diligent and only flew on Airbus, but there's a lot of places that aren't served by Airbus. So you're stuck with Boeing, and you need to know that Boeing is safe, and Boeing needs to be safe. Boeing is an essential company for the world, not just the United States, and Boeing needs to be run correctly, and they need to be accountable. Well, if every case involving their plane crashes gets settled, that is a limitation on their accountability, isn't it? So I think all of us need to be looking at our cases and say to ourselves, which of these cases really ought to be tried in relation to the public information function of tort? In law school, Ben, I was taught, and I wonder whether you were taught this, that the purposes of tort are to compensate and deter. And I was never taught that there is a public information function of tort. The person who educated me on that was Ralph Nader. And he was right about that. And I teach torts now, and I teach my law students that while it's not a traditional purpose of the tort system, at least not in the textbooks, as a practical matter, a third function of the tort system is to provide important public information.
Yeah, that certainly rings true. And I was not taught that. It was not in the bullet point list of the purposes of tort. And even the deterrence purpose is often dismissed away these days by many judges as sort of quasi-punitive and not appropriate to be talking about. There's a fine line there of trying to reference that purpose, as I'm dealing with post-trial motions now on certain issues. But I'm going to jump into a different place than I was going to go, because what you just said kind of raises this to the forefront. But I think a lot as a firm owner and as an individual lawyer, I think a lot about risk, managing risk. There's what is sometimes referred to as the first order consequence of a decision. So if you settle the case, you get the money, your client gets the money. If you try the case and get a verdict, you get the verdict. And then there's downstream consequences, some of which are reputational for yourself or for your firm. That's where your next case comes. That's how you build a career. There's also societal impacts, things like that. All of that has to be evaluated in a context of uncertainty, which is what we deal with that every day. How do you guys, both as firm owners and individual lawyers counseling your clients, and then even speaking to law students, how do you talk about the concept of risk, managing risk, and what, kind of a matrix for how you go about processing that in individual decision-making?
Are you referring to how do you handle the issue of risk when you're looking at a particular case?
Well,
or are you talking about making decisions with regard to the broad scope of running a law practice?
so to me, the two kind of go hand in hand, because you're talking about a portfolio of cases. So you're not making it on an individual basis, but then you do have an individual client. But More, I just wanted to let you run with it.
Well, let me take it. Let me take it in two categories. Let's take it first in the category of case selection. And on that, I think a lot of us are presented with the potential opportunities to get involved in mass tort litigation. And we have been very conservative over the years in selecting those mass torts with which we involve ourselves. And we probably, as they say, left a lot of money and success on the table by being conservative. I think we've been late to a lot of mass tort matters, and I think some we've passed on that ended up working out. But I want to be able to sleep easy at night, and I could only apocryphally water ski behind one yacht at a time, to take a concept from, I think it was Bonfire of the Vanities, where it was discussed that you can only water ski behind one yacht at a time. I don't water ski, but you get my point. You get my point. This is not a contest of who can be the richest lawyer. That's not what this is about. In my opinion, this is an experience, not an enterprise, an experience where we should be balancing our work with our personal life, raising children and staying married and being happy and playing squash or doing whatever it is you do to stay fit, and focusing on interests and the like, so that you're not just simply a work grind. And I think it's fine to take a pass on lots of potential opportunities. Don't be afraid to say no. Don't let seller's remorse drive you. Make the best decision you can every day about what projects you decide to get involved with. And we just say no to nearly everything, whether it's a big project like a mass tort or even individual cases. My goodness, Ben, on medical malpractice cases, we're saying yes less than 1 out of 200 times because the cases are so hard to win. So, and I'm just not afraid to say no. And have I seen other lawyers put together a case that I've turned down? Yeah, I have. Does it annoy me a bit inside of me that I took a pass on the matter? For just a moment. But then I think about the fact that, you know what? The facts as I knew them at the time did demand the conclusion to say no. That lawyer developed facts in a way that was really not foreseeable. Good for him. And by the way, not keeping score, but I've probably taken more cases that other lawyers have turned down and worked them out successfully for the client than I have had other lawyers work out successfully for their clients that I turned down. So I think if we're looking at a scoreboard in that way, I've nothing to be ashamed of. And I'm not going to torture myself about things that I said no to. On the issue of individual clients and judgments about whether to accept a settlement versus try a case, I try to include in that conversation more than simply the issues of money. And I tell people, look, you may be anticipating a negative experience in going into a courtroom, but please do consider the value to you, to what extent there is value, of having public accountability for the conduct that gave rise to this claim, and to the value that you will find by having the jury intone a verdict. You will never forget the foreperson intoning the verdict. Never. But if you settle the case, there will be no intoning, and there will be no memory of the jury rendering that verdict. And you will lose forever the opportunity to have a jury of your peers tell you who was right and who was wrong. Now, I had that conversation, and a lot of people, of course, most people say, well, what do you think we should do? And I do try to not make the decision for them because it's not my case, right? It's their case. But a lot of people don't understand these aspects of the value of taking their case to trial unless you sit down and patiently explain it to them. And in a lot of cases, Ben, there's no one who's really financially dependent upon the outcome of the case. If you end up getting less than you're offered, or you end up trying a case and getting a defense verdict when there was an offer, well, that could be a very different thing from person to person. If the case involves a brain injured child, and let's say it's a medical malpractice case, and there's been a fair offer made, there's a tremendous pressure on you as the lawyer to accept the settlement, because we have to take care of that child, don't we? But if it's a wrongful death case, like in the Boeing case I just described to you, where you had two professional employees of the United Nations, one of whom died and one of whom survived and was the surviving widower, excuse me, he wasn't dependent upon his wife's earnings, and they didn't have children, so there wasn't anybody that needed to be supported financially. So he could afford to, let's say, turn down an offer that was more than what the eventual verdict was. And he saw the value in having the case be tried. And the whole family did. And not just the widower, but also the administrator of the estate. And I mean, as it worked out, the verdict exceeded the offer. So
I
we,
would think it seemed like it would have. It was like a $25 million verdict.
I didn't. Yeah. We didn't have it. I didn't end up with any egg on my face, but I would not have felt there was egg on my face had the verdict been less than the offer, because I've been through this a bunch of times, and I know that different juries will do different things, and money isn't the only issue. And of course, the other part about that is, Ben, I'm sure you said this to a jury, money is such an inadequate substitute for life or for health. So the fact that we even have this system where we use money to compensate for a wrongful death or a wrongful injury is itself phenomenally inadequate. And of course, it's the best we can do, isn't it? Because we can't turn back the clock. We can't make the incident never occur. So we're stuck with money being all we have. But I think if we look at it in a fuller way, we think about the benefit of the public airing of the matter at trial, the public information function of tort. There is a greater deterrent function of tort by having cases be tried. That's obvious, isn't it? And then the memory for our clients of the experience of the trial and the jury's verdict, I think that needs to be weighed.
So let me ask you about. I mean, I've seen you present a number of times on some of your verdicts and cases. I can kind of project what you'd be like in a courtroom based on your presentations, but I'm curious how you would describe your courtroom style and what makes it effective. And then your partner, Tom Klein, I've seen him present. He seems like he has a very different style from you. I mean, my impression, I could be wrong, is that you tend to be a little bit more detail focused, a little bit more surgical, maybe a little bit more analytical. Tom seems to be a little bit more intuitive, maybe a little, but I'm curious about that, and also the fact that although you guys seem to have somewhat different styles, you're both highly effective, and what your impression is seeing many trial lawyers over the years as to what makes someone effective in a courtroom.
Thank you for all of that. Yes, I think Tom and I have been effective, and yes, I think Tom and I have been and are different. And I think we have different styles and different approaches. But here's the thing that we do that's exactly the same, and that is that we are ourselves in a courtroom. And Ben, I'm not you. I can never be you. And if I tried to pretend to be you, I would be a flop in a courtroom. And I think that's true of all of us. We should learn from each other, take the good, leave the bad aside, know how to distinguish one from the other, but do it in our own way. And yeah, I think I'm more, maybe I'll say sort of business-like. And, my hair is short, and and I wear a dark blue suit every day, and I wear a white shirt every day, and I wear a red tie every day. And I, particularly when I'm trying a case not in Philadelphia, or it's not in my hometown, I am extraordinarily careful because I recognize I'm a guest, and I don't put my feet on the furniture, either literally or figuratively. And I just tried this case in Chicago, and against a very famous, probably the most famous Chicago lawyer there is. And, I know where I am in that situation. And I just believe the things that I was taught by my mother and my father. You don't get a second chance to make a good first impression. And if you don't have anything nice to say, don't say anything at all. And I could carry on these aphorisms for a while, but you get my point. Just apply your own values and your own personal approach outside of the courtroom to the inside of the courtroom. Don't vary in the slightest. I was teaching the other day, and 2 days ago, and I asked my student to explain the case, and she started to explain the case, and she's a first-year student, and I wasn't that good. And I said to her, I said to her, I said, respectfully, I think that the way you're explaining the case is the way you think that a lawyer would explain a case. And she's a first-year student, so, she can't really pretend to be a lawyer. So I said, I would rather that you explain the facts of the case as you would if you were sitting across from a friend at Phil's coffee shop up the street. Please start over. She started over, and she applied that. And she did a perfect job, not a good job, a perfect job, because she was just being herself. She wasn't being what she thought she should be pretending to be. And I think if we do that, that's the first step in being good. Um, and then there's a lot of other things that go into it. Is to being sensitive to the moment. Last night at Stanford, I played a videotape for my class about involving a drug product liability case where the president of Merck Research Laboratories was defending the company by explaining how his mother had taken Vioxx, which was the drug involved in the case. And of course, we had confidence in Vioxx. We wouldn't have let our mothers take Vioxx if we thought there was any problem with the drug. I mean, it's a superficially attractive argument, isn't it? And I had to cross-examine that. And so I said, I don't want to ask you about your mother, sir, but you brought it up, and so I'm going to have to ask you a few questions. And I started to ask him about his mother, why she was taking the Vioxx, and what he knew about her experience on Vioxx and the like. And he started talking about it. And I felt myself being uncomfortable that I was asking him about his mother, even though he made me do it. And even though I said, I don't like asking you this. Anyway, after a while, I said to him, again, this came from a wellspring of how I was raised. I said to him, sir, does your mom know that you're talking about her like this today? Okay, that's not a question lawyers would tend to ask of witnesses in a courtroom. It's the kind of thing you'd say to somebody in a coffee shop where you were concerned about their behavior. Anyway, he looked at me, and he had that look on his face like, wow, I really did something wrong, didn't I? And he said, my mom doesn't know about talking about her this way. I said, are you going to tell her? And he said, yes, I am. I thought to myself, if this is ever shown to a jury, this is going to be a good moment, because this is like this. Yeah, they may think there's some there's some logical inference a jury might draw about the safety of the product from the fact that the family took it. But the overwhelming fact of it is you're inappropriately discussing the personal health of your mother without her permission or knowledge. And again, where does this stuff come from? Like the judgment about it? Well, just being yourself, thinking about things like a mature adult, like I hope a decent human being, and also in the moment being relaxed enough to be able to freely think through what's happening with me now. I'm asking these questions. I feel uncomfortable. If I feel uncomfortable, then maybe the jury watching this will share that discomfort. Maybe I should pivot from that and utilize that discomfort and turn it back on the defendant. How can I do that? And again, if I'm relaxed, if I've slept well the night before, if I don't have caffeine on board or sugar on board, at least those are important things for me from a diet and rest standpoint, and I can think more clearly, I can get myself to a place where I can ask, I hope, good questions that will help my client's cause. A lot of that isn't a matter, Ben, if you think about it, of necessarily a preparation. It's not a matter necessarily of, it's not theatrics, but it's a matter of, again, staying within yourself and knowing who you are and acting the same way in the courtroom as you do in a coffee shop.
Yeah, I mean, that's such a great insight, and it sounds so simple. And it once a younger lawyer who's hearing this will think, well, that's kind of common sense and a no-brainer. But try, trying some high leveraged, stressful trials and see what you're like when you're in that moment and whether you're capable of doing that and getting to the point where you have your mind is open to that and your intuition is raised enough to be able to execute those kind of things. That's higher level stuff, and it isn't something you can really teach, but it's worth saying that so people have in the back of mind and maybe can execute when the moment comes. Just a couple more things because we're about at the hour, but I'm curious about the business, your firm. I mean, we had a discussion at a recent meeting where you encouraged me to do some more direct to consumer marketing. We actually followed that advice, and for the last 3 or 4 months, we're doing that, and I've enjoyed it. Actually, we're really trying to target a message the way something we're comfortable with that will resonate. We tested it. It's been successful. But in looking at other examples of plaintiffs' practices that have effective vertical integration of being effective at marketing directly to people on the street and also doing high-end trial work, there aren't that many examples across the country. I mean, obviously, Arlen Specter is one, but there aren't many others. What was your philosophy behind doing that? Because it is kind of an exception rather than the rule. And how has that been? Why have you been able to pull that off where very few other firms have?
I've always been interested in marketing, so I think I come to it naturally. I've helped to run a lot of campaigns for public office. I think there are certain similarities between somebody running for Congress and, just as an example, and someone who is a lawyer and is informing the public about their accomplishments and what's important to them and what they have to offer. So I think that's helped me in conceptualizing television advertisements and the like. But of course, lawyer advertising is very dynamic, multifaceted, and changeable. And so I'll raise something with you and your audience that I think will hit home with many people, and that is the issue of lawyer billboards. You cannot drive in a major American city today without being impressed, I'll use that word, at the high percentage of billboards that are utilized by lawyers. And you don't have to think well of yourself as a practicing lawyer to think not well of some of the billboards that appear. Some of them are fine, some of them are not fine. God knows what the public thinks about some of the billboards. I'm not sure that it really helps our profession that we have so many of the billboards and some of the messages that are on the billboards, but there's no regulating the billboards, right? People have a constitutional right for the last 50 years to put up billboards, and they've been doing it more and more. Anyway, in Philadelphia, which is wall-to-wall lawyer billboards, we put up a billboard. We put up several billboards, not too many, just enough so they could be seen. And here's what they say. Don't hire a lawyer based upon a billboard. Don't hire a lawyer based upon a billboard. The billboard, just so you have a mental image of this, is almost entirely white. The message that I just articulated is in small letters. You have to work for it to read it. And then in the lower right-hand corner, in very small letters, is our firm logo. And again, you have to really search to find on the billboard who put it up. And the billboards have been a staggering success. They have caused enormous conversation, not just in the legal community, but in the lay community. There's been a lot of social media about it. There's been a lot of discussion about it. There have been lawyers from around the country who have told me they've heard about the billboards. They've seen images of the billboards. They're going to put up that billboard themselves in their own community. They've actually asked me if I have an objection. And I say, of course, I haven't. Not only I have no objection, I'm delighted to hear it. I just want you to send me a picture of your billboard, after it's up so I can see it. And, people shouldn't be deciding who to hire based upon a billboard. It's not enough information. It may be a starting point, but it's not an ending point. And, I think I feel good about that billboard. And now I'm going to do the same thing, Ben, on the buses. Again, the buses are plastered with lawyer advertising. I'm going to put an ad on the buses that say, don't hire a lawyer based on a bus ad. And I'm going to do the same thing in the subway cars, where again, they're plastered with lawyer advertisements. And it's going to say, don't hire a lawyer based on a subway ad.
Let me give you one. And
Right.
if you pull it off, I want credit, but I think you should run a 60-second TV ad with that on the screen for 60 whole seconds and nothing else.
Well, here's what we've done on that. We have bought 5-second commercials from those stations that will sell them. Not every station will sell them, but we simply have the billboard on the 5-second ad, and a voice comes up and says the words on the screen. Don't hire a lawyer based on a billboard. I don't need 60 seconds to articulate that message.
That's
I don't
the whole
want
point. I just think of it because
Yeah.
when one of our senators, Angus King, first ran for Senate, his very first ad was "Turn off the TV," and the TV screen looked as if the ad was designed to look as if the TV went off, and then it just stayed off. But it was an extremely memorable ad. It didn't say
Wow.
anything else. It was about in order for our kids, the best thing you can do is just turn off the TV, and then the TV, and it was Angus King, and it was just I've always been struck at how effective that was. I mean, it's 20 years. I still remember that ad, and it's kind of similar to the concept you have that less is more, and just I'm paying for 60 seconds to show you a single message that is don't choose a lawyer based on a TV commercial.
I think you're onto something. I just think 60 is a long time.
It'll sink
What
in
I'm going
over
to do
that time, though. That's the point.
Yeah, when I get off with you, what I'm going to do is I'm going to have our guys make it up as a 15 and as a 30, and I'm going to look at it as a 15 and a 30 and think about it. But
The other point,
it's a very
my
good
other
idea.
insight into it is take your logo off of it, because that's
Well, there's
really
a bit of an
ballsy.
issue. Yeah, there's a bit of an issue there because the billboard company requires you to identify yourself.
Okay.
So I can't entirely. I could put the tiny letters at the bottom kind of thing, but
Because people would know it was you anyway.
Yeah. Well, there is something to that. I have thought about that aspect, but I put it small enough. One of the lawyers in our firm said, I think you should change the billboard. I can barely read the logo. I said, well, if that's the case, it's exactly the size that I want it to be.
No, I did see a photo of it, and I think it was a brilliant marketing campaign. So we're fortunate in Maine; they don't allow billboards here, so we don't have our
Who doesn't allow them?
the state. They're just not. It's not a discriminating against what the
Oh,
message
oh,
is. We
I
don't
see.
have billboards at all. There are no billboards as a matter of
I
zoning,
see.
I guess.
On a zoning
Yeah.
matter. I see. That's a great benefit to you, Ben, as a practicing lawyer in Maine, because respectfully, I don't think you want to compete with the billboard lawyers.
I really don't.
Right.
Well, Shannon, I really appreciate you coming on and chatting. I know you're
Thank
very
you.
busy. And also, I mean, it's worth saying you've been so generous of your time and advice to me, especially as we were getting our firm off the ground. We've modeled a number of our things after stuff you've done. And so just really appreciate that.
Thanks, Ben. All the best to you. Thank you.